In the present class, discuss the question that is the most probable question in the examination, that is what is meant by agency, and discuss the modes of creation of agency. So here in our present class, we are going to discuss with regard to this question, and also the most probable question in the examination is discuss agency and discuss the modes of cancellation of agency. So these the questions are most probable questions in the law exams. Either they may ask with regard to the modes of creation of agency, or they may ask with regard to the termination of agency. Here the question with regard to the what is meant by agency, that is common question. So in that way the question may be asked in the law exams with regard to the law students. Here they will ask you with regard to the what is contract of agency. So with regard to the contract of agency, with regard to that questions, the agency has not defined in the Indian Contract Act, but it has defined the who is an agent. That means who is an agent. So who is an principal. That means here we can get what you call here with regard to the agent, the definition has been given, but with regard to the agency, the definition has not been given in the Indian Contract Act. So here with regard to that one, what we have to do with regard to the how to write the concept with regard to the contract of agency means we have to write who is an agent. That means that we know who is an agent and who is a principal. We could be able to write with regard to the aspect of the agent and principal. So under section 182 of the Indian Contract Act, the agent has been defined. That is, an agent is a person employed to do any act for another or to represent another in dealings with the third person. There is another means here stands as a principal. Here, who is a principal? We know that with regard to the who will be a principal. So with regard to that aspect, here when the question has been asked what is an agency, then what is a contract of agency, then three things we have to write with regard to the concept of agency. That is, one is essentials of agency, and next one is principles of agency, and the test of agency. So these three things we have to cover with regard to the concept of what is contract of agency. That you know what are all the essentials of the agency. That means there should be an agreement between the principal and the agent, and we have to discuss with regard to the capacity of parties. Even under this capacity of parties, we can even a minor can also he can act as the agent, and who can become the principal. Here a minor cannot become a principal, but he should be of sound mind, he should be major. So those things we are going to see under this concept of essentials of agency. And with regard to the what are all the principles of agency means, so under principles of agency we have to discuss with regard to the one maxim, that is qui facit per alium facit per se. That means he who does an act through another does it by himself. That means it means that the act of an agent are deemed to be the act of the principal. We have to discuss this aspect. That means I am telling you what are all the things we should cover with regard to the what is meant by agency, what is meant by contract of agency means we have to cover the aspects of essentials of agency, and we have to write something with regard to the principles of agency, and we have to write a very important thing is that is a test of agency. So what should be the test of to prove that the agency exists? So the test is that to determine the existence of agency, it has to be seen that whether the agent who has been appointed by the principal has got the authority to bind the principal for his acts. Whether the agent could be able to bind the principal for the acts with the third parties. So we have to discuss the test of agency. Here the case law of Loon Karan versus John and Company. It is very much relevant. So we have to discuss these concepts with regard to the contract of agency. That means we have to say something with regard to the fiduciary relationship between the principal and the agent, how the agent has to work. So this is with regard to the contract of agency. That means here with regard to that questions, that is a common. What is contract of agency? And in examination they will ask you discuss the modes of creating agency. That means that is the additional question with regard to the mode of creating agency or method of creating agency. Here with regard to the what is the mode of creating agency? What is meant by how the agency can be created? So that with regard to that aspects, we have to see certain aspects before going to the concept of modes of agency. Here, when any one party delegates some authority to another party, whereby the latter performs his action in a more or less independent fashion on behalf of the first party, the relationship between them is called an agency. Here, some more points I want to give you with regard to the agency. Here, when any party delegates some authority to another, that means who can delegate here? The principal delegate some of the powers to the agent, whereby the latter performs his actions in a more or less independent fashion on behalf of the first party. The relationship between them is called an agency. So here agency can be expressed or implied. So under chapter 10 of the Indian Contract Act of 1872 deals with the laws relating to agency. It is important to know the law relating to agency because nearly all transactions worldwide are carried out through agency. Here much widely the commercial transactions more or less which has been carried out through the process of agency only, whether it may be big or small. So here the contract of agency, which is proving very much it is proving to be a catalyst role. So here therefore law relating to the agency are important area of business law, and relationship relating to principal and agent involves three main parties, that is principal, agent and the third party. Here I have told you with regard to who is an agent. An agent does not act on his own behalf but acts on behalf of the principal. He either represents his principal in transaction with third parties or performs the act for the principal. So the question as to whether a particular person is an agent can be verified by finding out of his acts whether it can bind the principal or not. So this aspect I have told you. That means what are all the things we have to discuss with regard to the what is meant by contract of agency. So here let us see how the agency can be created, which are all the modes and which are all the circumstances we can see the contract of agency can be created. Here, as you know, the creation of agency can be created under these headings, that is agency by express agreement, agency by implied agreement, agency by necessity, agency by the ratification. Next one is agency by operation of law. So under these headings agency can be created. That is, here we can see that is the first aspect is the agency by express agreement, agency by implied agreement, and second one is agency by implied agreement, under which we can see there are three varieties we can see. That is under this implied agreement we can see agency by necessity, agency by estoppel, here agency by holding out. Here agency by estoppel also will come, agency by necessity will also come, but we can include agency by holding out also. So here these are all the things we can see with regard to the implied agreement. That means here agency by holding out, yeah, we can include this one also. That means here under agency by implied agreement, we can have agency by estoppel, agency by holding out, and in certain books they have included the agency by necessity also. That is under necessity. There what we can see, this under necessity, there will not be any anything with regard to the original contract with regard to the aspect of necessity, but it will arise depending upon the situation. So let us see one by one. Here with regard to the agency by express agreement, here an authority is said to be express when it is given by words spoken or written. So this is very much important with regard to the how the agency can be created. That means we here, if the principal he creates he appoints any person as his agent by way of writing or by way of expressing his wish through by the words. That is common. Here you can explain this aspect. And here with regard to the certain times, the agency may be by implied agreement also. So here how to analyze this agency by implied agreement means it is an authority is said to be implied when it is to be inferred from the circumstances. That means here how we can infer from the circumstances means here it depends upon the conduct of the principal. That means conduct of the agent. That means here an authority is said to be implied. That is when it is inferred from the circumstances means from the conditions. So in which how the principal will behave with regard to the certain aspect. So under which we have to discuss with regard to the three aspects. That is agency by holding out, agency by estoppel, and agency by cohabitation. Here what is meant by agency by holding out? Here agency by holding out means what happens if a person allows other person to enter into a contract, then first person for all the act done in the course of employment, he will be held responsible. Here what happens if a person allows some person to act on behalf of him, for example a servant, what he will do, he will go to the shop and he will buy the goods on credit, and later the principal used to give the money to the third party, that is the dealer, that is from where the servant has got the goods. Suppose here at one time what happens if the servant gets the goods, but he will not give that goods to the principal. So even under such circumstances also, a principal will be held liable, because here what happens, he allows that person to act upon him, behalf of him, that means in the course of his employment. So here the principal, when he allows, when he does not say that such and such a person, he is no more, he is an agent of him. So if it does not express clearly that certain person has not is not working as an agent on behalf of him, he will be held liable for the acts of the agent. So this can be seen under the agency by holding out. So then next aspect, agency by estoppel. So here how this agency by estoppel means, what is the meaning of estoppel means, if a person by conduct or word spoken or written willfully makes another person to believe that certain person, certain agent, he is acting on behalf of him. So if a person by conduct or word spoken or written willfully makes another person, that another person is third person, to believe that the certain person, that is agent, he's representing on behalf of him. For example, if an agent, we can presume that agent is A. He tells B in front of C, that is C means here principal. Agent tells to the third person in front of C, that is principal, that he is the agent of C. And after hearing that aspect, if the C does not object to the statement of A, then suppose B supplies or he contracts with A, that is the third party contracts with A, then C has to pay for the goods supplied by B to A. So this aspect we can see that under the concept of estoppel. That means these are all things we can see under implied what we call agreements. So this will come under the implied agreement. Certain times here the agency by necessity also it will come, but I think it will be right to discuss under the separate heading. And under the agency by implied agreement, one more thing is there, that is agency by cohabitation. Here, among whom this agency by cohabitation which will come is, it will come among the husband and wife. Suppose the society believes that certain what you call a couple who lives in for a certain reasonable point of time, that as a husband and wife, and they may be living in partners also, except the what you call concubine. Yeah, living in partners, living in relationship also. If they make them believe that they are the husband and wife, if any act done by the wife, that means here whatever things in this we have to see that the act of the parties is very much important. That means here the principal is the husband, the agent is the wife. So the act, the conduct, the behavior of the principal, that is the husband, which is in such a way that the society has believed that the certain what you call lady, she is the wife of the certain person, and believing that one, believing in the what you call past conduct of the principal and the wife, and with regard to the transactions with the third party, if any what you call the third party gives the goods on credit to certain lady who is acting as the agent for her husband, then also the husband will be held liable. So that will be seen under the concept of agency by cohabitation. So next important aspect is agency by necessity. Here, with regard to the agency by necessity, a very important thing which has to be discussed, that is what is meant by agency by necessity. Here, agency of necessity, which has been developed from an original and subsisting agency and applies itself to unforeseen circumstances. That means that is events which could not be predicted. So unforeseen events not provided in the original contract. See here, agency of necessity which will arise with regard to the subsisting agency, that is original to the original contract, but which is not provided in the original contract. That means the events which has got the series of connection with regard to the original contract. That means agency of necessity develops from an original and subsisting agency and applies itself to unforeseen circumstances, events not provided in the original contract. Here, with regard to the agency by necessity, there are certain case laws are very much important. That is Great Northern Railway versus Sheffield. So that is the case law with regard to the delivery of the horse. That means here with regard to with regard to delivery, the delivery was DELIVRY. That means don't think of another delivery. Here what happened? A horse has been booked under shipment in railway, and when it has reached the particular destination which was not received by anybody, and the railway company has meted out the expenses of the horse. So here that reasonable expenses has to be borne out by the the principal. So that is seen under the Great Northern Railway versus Sheffield. So this is a similar case law with regard to the co-chair versus HT. That is in this case law, that is with regard to the cargo aspects. That means here there was some decayed the decayable cargo was there in ship. So there what happened? The captain of the ship, he has sold the cargo for the best price. So here the principal has he has to accept the action taken by the captain. So those things we can see under the agency by necessity. That means it should be in the interest of the principal only. And next one is agency by ratification. Here this agency by ratification is also very much important thing. Here what happens when any act done by the one person on behalf of the another, without his authority or knowledge, the person on whose behalf the act is done has the what you call for the following options. That means he can disown his act, or he can ratify the same. That means here if any act has been done on behalf of another person without the authority, so same thing we can see with regard to the agency by necessity, but their necessity comes there. But here there without his authority or knowledge, the person on whose behalf the act is done, he has got either whether he can deny or he can accept that act. If once he ratifies that, it is as good as he has permitted such a person to act on his behalf. So here what happens, for example, here A insures B's goods without his consent for certain amount, and if P or if P that is a principal ratifies the act of his agent, that means ratifies the act of a person, that is the insurance policy is held to be valid. That means here some person he insures some goods belongs to some person without the consent of the principal. So at the time, if principal ratifies the A's act with regard to the insurance, then it is held to be a valid. It is a valid ratification. So here with regard to the ratification also, you have to discuss with regard to the essentials of the valid ratification. Here with regard to this one also, the independent question may also come in the examination with regard to the agency by ratification. Here there are nearly 7 the essentials are there with regard to the valid ratification. That means here the ratification should be of the whole transaction. That means ratifications should not be done for the part of the transactions. That likewise the certain things are there. That means the ratification should not be done for the which is against to the interest of the third person, and ratification should be made with reasonable time, and the act should be done on behalf of another person. The principal should be in existence and competent to contract when the act is done. Likewise, here with regard to the valid ratification, certain conditions are there. That means when the principal, when there is a ratification is there, when any act has been done by the agent, at that time the principal should be in existence. Otherwise, it will not be a valid ratification. That means in future some company is going to come up, or any things are going to come up with regard to any future happening contingency. If any ratification, if any what you call the process, if any agent acts and he makes any contract, hoping that in future some company may come up which is not in existence. So then also such ratification will not be a valid ratification. So those aspects we have to see under the essentials of the ratifications. So with regard to the ratification also, it may be express or implied. So what we have seen earlier here, which may be the express or implied also. Here these are the things we have to see under with regard to the agency by ratification. Then last aspect is agency by operation of law. Here, how this agency by operation of law will be created means it is created by the act of the law. That means here what happens, as you know that company is a artificial legal person. So here when the company is a artificial legal person, the promoters who has to act on behalf of the company. So the promoters who has to act on behalf of the company, they will be called as agents. So here under agency by operation of law, we have to discuss the promoters or agents of the company, and partners or agents of the partnership. That means by the operation of law, these promoters will act as their position will be like agents, like in the with regard to the company, like with regard to the partnership firm, which is also a artificial legal person. There the partners are also act as the principal as well as the agents. So these will come under the agency by operation of law. Then we have to discuss with regard to the other aspects. Here we have discussed so far we have discussed the modes of creation agency. It can be called as model or methods of creating agency. That means here by actual authority being conferred on the agent to act on behalf of the principal, such authority may be either express or implied. So this is the very important thing. We have to see how the mode of agency or method of creation of the agency. Here by agent's authority to act on behalf of the principal is a situation of emergency. So these aspects we have seen. By the conduct of the principal, which creates an agency on the basis of the law of estoppel. So we have seen the law of estoppel and the principle of holding out also. By ratification of the agent's acts by the principal, even though the same has been done without the principal's prior authority. So this what is meant by ratification also we have seen. By presumption of agency, that is husband and wife relationship. So these are all the modes of creation of agency. Then with regard to the most probable question with regard to the termination of agency, either they can ask the mode of creation of agency, or they may ask with regard to the termination of agency. First they will ask with regard to the what is meant by contract of agency. Either they can ask with regard to the mode of creation of agency, or they may ask with regard to the termination of agency. Here what is meant by termination of agency means under which are all the circumstances under which a contract of agency can be terminated. That means here we have to discuss which are all the context, which are all the circumstances under which a contract of agency can be terminated. So here under termination, who can terminate the agency, that is also very much relevant. Here as you know that there in the contract of agency there will be principal, agent and third party will be there. So here the main contract will be between the principal and the third party that has been created, that has been done by the agent. So here who has to terminate the agency? Here this aspect also we have to see with regard to the termination of agency. That means who can take the lead with regard to the termination of agency. And one more context here, this termination of agency can also be, it will also can be taken place by the operation of the law also. So let us see this termination of agency. Here the termination of agency may be by act of parties or by the operation of law. Here under the act of parties we have to look into the by agreement. Here this termination of agency will be on the here the law allows termination when both the principal and agent are agreed. So here by the act of the participant by agreement between the principal and agent, the agency can be terminated. That means here law allows the termination of agency when the principal and agent are agreed. So here that is the first aspect. Second one is revocation by the principal. That is revocation means taking back the agency or cancelling the agency. So even before completion of the performance of the any task, then the principal has got the liberty to terminate the agency. That means the principal reserves the right and terminate the contract with agent at any point of time. But here what he has to do, he has to give the notice to the agent and keep his action. He should inform the third party. That means he has to inform the third party and he has to give notice to the agent. So this is the right thing that under this is the way of what you call revocation of the agency. Here, if the termination of agency has been terminated within the reasonable time, then the principal he need not have to give any what you call any sort of the remuneration to the agent, but he has to, if it's not within the reasonable period of time, then he has to give the remuneration or loss to the agent. So same thing which will be applicable with regard to the revocation of the agent, revocation by the agent. So this is the right that provided under the legal framework, that even an agent also he can revoke the termination of agency, revoke the contract. That means what he has to do, he has to give the notice to the principal, or he has to submit an application of resignation to the principal within the reasonable period. So if before the actual date, that means here if he does not act within the reasonable period, then the principal can reserve this right of demanding the loss accrued to him by the act of his agent. So these things we see with regard to the concept of the aspect of revocation by the agent. Then let us see with regard to what are the aspects which will be concerning to the operation of law. Here, how this operation of law will be will be caused to terminate the agency. Here there are 8 8 circumstances under which by operation of law the agency can be terminated. Here what happens, first one is when particular object is accomplished. That means when certain task has been given to the agent. For example, in order to sell, suppose the principal has given a task to the certain person agent to sell his house. So when the house has been sold out, the object for which the task has been given to the agent has been completed, so that it automatically the agency will be terminated. Next one is expiry of time. So with regard to the any aspect, suppose a principal he makes some contract with the agent, that means to supply the goods to the third party for a period of 1 year, 12 months or 10 months. So after the expiry of that time, the contract of agency will be terminated. So here either maybe by way of completion of the object or accomplishment of the object, or the object which has been completed, or by way of expiry of time also the agency may be terminated. Next one is death or insanity. So by this one also the contract of agency can be completed. That means by death or insanity of one of the parties. That means here with regard to almost all the transactions, almost all the aspects, here the death or insanity, the rescinding will be there. So the agency will be terminated by the death or insanity of the one of the parties. So the same aspect will be applicable with regard to the insolvency also. And next one is dissolution of company. Here with regard to the dissolution of company, what is the procedure and what is the status of company, all those things with regard to the dissolution of company, what are all the procedure of winding up and also all those things. So when the winding up procedure has been started, so automatically all the contracts of agency which will be terminated. So that is also one of the aspects we have to see under the operation of law. And next one is destruction of subject matter. So here what happens, when the subject matter of the contract of agency itself it will be no more, then how can we can expect the contract of agency can be which can be subsists. For example, Ravi employs Kirti to take insurance for his house in Vizag from June 2021. But what happens here, the house, so for example here what is the problem, I will repeat the problem. Here Ravi employs Kirti to take insurance for his factory. Instead of a house, I will take a factory in Vizag from June 2021. But the factory which met with fire even earlier to that proposed the fire insurance which is going to buy agent Kirti, which has where the fire explosion has been taken place in the month of May 2021 only. Here Ravi, he wants to take the fire insurance policy in the month of June 2021 with regard to his factory through agent Kirti. He wants to take that fire insurance policy, but before taking that policy only, even though he is authorized his agent Kirti, his factory has went in the has damaged in the fire explosion, then also the contract of agency, that is it can be terminated by the operation of law. And next one is termination of agency when principal become alien enemy. So how this principal becoming alien enemy is, for example, suppose a principal is in India. Suppose here we can take the aspect with regard to the two nations. For example, suppose a principal principal is in India and he appoints some person is happened to be a agent from China. So there will be some business transactions will be there. He made some contract of agency and he has appointed some person from China as an agent, and there some war has been broke out between India and China. There will be some war atmosphere will be there. So when such a war has been broke out or some war climate has been created among India and China, then the China at the instead of China, this principal from India, he will be converted into a alien enemy. So when principal becoming alien enemy also, then contract of agency will be terminated. So this is the example with regard to the principal become alien enemy, where a person from one nation, he employs another person from another nation, where there will not be any good relationship between these two nations, and if there is any war sort of any the atmosphere has been created at that event also, the contract of agency could not be performed to fullest extent. So at that time also the contract of agency can be terminated. And the last aspect is termination of sub-agent's authority. So under which this aspect also there will be termination of agency will happen. Here these are all the aspects we have covered under the termination of agency by act of parties, that is agreement, revocation by the principal, revocation by the agent. So here under these two headings the agency can be terminated by act of parties, that is by agreement between the principal and agent, and revocation by the principal and revocation by the agent, and by the operation of law all these aspects will be there, that is the performance of the contract, expiry of time, death of either party, insanity of either party, insolvency of the either party, destruction of the subject matter, principal becoming an alien enemy, dissolution of company or termination of sub-agents authority. So this is the aspect we have to see with regard to the most probable questions in the law examination. They will ask you with regard to the what is meant by the contract of agency. So when such question has been asked with regard to what is meant by contract of agency, I have told you that you have to write three aspects. That is, you have to write with regard to the what are all the essentials of the contract of agency, and you have to write the principles of agency. You have to write the test of agency. Then, if the question has been asked with the method of creating of agency, we have to write the methods or modes of creation of agency. So that is also very much important. And they may ask you with regard to the mode of termination of agency. So under which you have to write these the modes of termination of agency. So if you remember these points in this table, it will be very much easier for you to face the examination. So this is about the question, that is what is meant by contract of agency, and which are all the modes of creation of agency, and what is meant by contract of agency, which are all the modes of termination of agency.